Okay, criminal procedure in the Constitution, leading Supreme Court cases, and introductory text. Chapter 1, a criminal justice process overview. This book presents a collection of leading Supreme Court decisions in the field of constitutional criminal procedure. That is, decisions dealing with application of the United States Constitution to what is commonly described as the criminal justice process. That process consists of a variety of different procedures, some applied by enforcement officials, police and prosecutor, and some applied by courts, through which the substantive criminal law is enforced. The court's opinions commonly focus on the application of a single procedure in the context of the individual case before the court. The court tends to refer only briefly, if at all, to other procedures that are part of the process, and only occasionally describes the overall legal and institutional structure that provides a frame of reference for its criminal procedure rulings. That backdrop is assumed to be familiar territory for the lower court judges who have the responsibility of interpreting and applying the court's opinions, and the prosecutors and defense counsel who will advance legal arguments based on those opinions. We assume that it is not familiar territory for the students using this casebook, and therefore seek in this chapter to briefly describe the three components of that backdrop: the division of lawmaking authority in the legal regulation of the criminal justice process, Section 1, the division of responsibility for the administration of the process and the range of diversity within which administrative grouping, Section 2, and the basic steps that carry the administration of the process from its starting point to its conclusion, Section 3. 1. The lawmaking structure. 1. 52 lawmaking jurisdictions. Under the United States version of federalism, each of the 50 state governments retains the authority to enact its own criminal code. Each state also retains the power to provide for the enforcement of that criminal code through agencies and procedures that it creates. That authority has been used in each state to establish what is a single general criminal justice process applicable through the state. Congress has added these 50 state criminal justice processes. It's two distinct federal criminal justice. Congress has added to these 50 state criminal justice processes its two distinct federal criminal justice processes. First, it has created a separate criminal justice process for the District of Columbia, used to enforce a separate criminal code that applies only in the district. Second, it has created a criminal justice process for the enforcement of general federal criminal code, which applies throughout the country. This process utilizes national federal law enforcement agencies and relies on prosecutions being in the federal district courts. While the federal criminal justice system has expanded greatly over the last half of the 20th century, the state criminal justice systems remain the source of the vast majority of criminal prosecutions. The state systems account for almost 99% of the nation's total criminal docket, i.e., all prosecutions of felonies, misdemeanors, and those local ordinance violations that carry a potential sentence of an incarceration, and roughly 96% of all prosecutions charging major offenses, i.e., felonies. Thus, not surprisingly, a substantial majority of the Supreme Court decisions contained in this volume review state prosecutions. Diversity in state law. The presence of the 52 lawmaking jurisdictions does not invariably produce substantial diversity in the laws of those jurisdictions. In other fields of law, the individual states have almost uniformly adhered to a single model, so that the governing law is quite similar in almost every state. That has not been the case, however, for criminal procedure. The English common law provided a common starting point for the criminal justice systems of the original states and the federal system, and continues to provide an element of commonality even to this day. However, as the common law concepts have been adjusted to accommodate new developments in the administrative structure of the process, such as the creation of police departments, and as the process has been reshaped to accommodate new concerns, various factors have led the states to take diverse approaches on common issues. Four factors in particular point to different states adopting somewhat different legal regulations. One, criminal procedure is not one of those areas of lawmaking in which the need for reciprocity or the interaction of transactions forces the states to seek uniformity. A lack of uniformity in the criminal justice process for adjoining states is not likely to be a deterrent to the free flow of goods, services, or persons between the states, or to restrain economic development within the state. Two, the criminal justice process must be shaped in light of the state's administrative environment, including the demography of the population, the resources available to the process, and the structure of the institutions responsible for the administration of the process, particularly police and prosecutor agencies, and thus vary considerably as to that administrative enforcement. And third, criminal process issues tend to be issues of high visibility and often high emotional content, leading to lawmaking decisions, at least legislative lawmaking decisions that are influenced more by symbolic politics, which tend to vary with the ideological assumptions of the local constituency and the views of those with presumed technical expertise. And for the integrated character of the criminal justice means that a divergence between states in their law governing one part of the process most likely will necessitate further differences at other stages of the process. Third, the unifying role of federal constitutional regulation. The Bill of Rights of the Federal Constitution includes a large number of guarantees dealing specifically with the criminal justice process. All the guarantees of the Fourth, Sixth, and Eighth Amendments, and with the inclusion of the Fifth Amendment due process clause, which clearly applies to criminal proceedings, although extending also to certain non criminal proceedings. But all but one of the guarantees, the just compensation guarantee of the Fifth Amendment. As discussed in Chapter 2, these provisions originally applied only to the federal criminal justice process and the District of Columbia process. However, as a result of a series of decisions described in Chapter 2, almost all of these provisions now apply as well to the states. Moreover, in its reading of the due process clauses of the Fifth and 14th Amendment, the court has carried constitutional regulation far beyond the subjects regulated by the more specific guarantees, recognizing that as it applies to the states, due process also has a content independent of the selective incorporation of the specific guarantees noted in Chapter 2, Section 3. The Equal Protection Clause of the 14th Amendment, in its prohibition against discrimination, provides still another layer of constitutional regulation of the criminal justice process. Federal constitutional law regulating criminal procedure, as interpreted by the Supreme Court, is commonly described as our most important source of criminal procedure law. LaFave et al. And Supra in section 1.3b. This characterization stems in part from the fundamental character of the issues considered in the court's constitutional decisions and the symbolic importance or significance of the principles announced in its rulings. The characterization also is based in part on the practical bearing of the court's constitutional rulings. Federal constitutional law is the only source of substantial legal regulations applicable to all 52 jurisdictions. As such, it provides a common foundation that significantly shapes major portions of the process in all 52 jurisdictions. It should be kept in mind, however, that constitutional regulation is still too significant limitations insofar as it relates to achieving uniformity among the 52 jurisdictions. Initially, the Constitution imposes no more than a baseline standard. It prescribes procedural prerequisites that each jurisdiction must meet as a minimum, but the jurisdictions remain free to describe additional procedural protections if they so desire. As to almost every area of constitutional regulation, at least one jurisdiction has imposed a limitation upon upon governmental action more restrictive than that imposed by the federal constitution. Very often, where the court majorly has rejected an expansive view of a particular guarantee, and dissenting justices have favored that interpretation. At least a few states have adopted the expansive view under state law, in some cases, in the interpretation of state constitutional guarantees almost identical to the federal guarantee. In many areas, a substantial majority of the states have adopted standards that go beyond the constitutional minimum. Thus, while the constitutional right to jury trial allows for 6-person jury for a trial of non-capital felonies, see Chapter 24, Section 1. Second, constitutional regulation is far from comprehensive across the totality of the criminal justice process. As to some procedures such as searches and seizures, federal constitutional regulation is quite detailed. Indeed, some would argue that it rivals the Internal Revenue Code in its complexity. However, as to many other aspects of the process, example, the negotiation of guilty plea agreements, constitutional regulation will reach only a few major features of the particular procedures. The remaining aspects of the procedure will be regulated by state law, if regulated at all. The cases presented in this volume, which do not cover even the totality of constitutional regulation, should not be viewed presenting anything close to a complete picture of legal regulation of the criminal justice process in all 52 jurisdictions. What those cases do illustrate are the fundamental overarching principles that largely shape the legal regulation of this nation's criminal justice processes and the complexities that arise in applying the principles to specific cases. And take a break before going into the administrative structure.